Good afternoon, everyone. Thank you for attending today's webinar. Today is a quick skills webinar that will cover legal requirements for meeting minutes. My name is Jennifer Medja-Sanchez. I am a regional director here with FirstService Residential. This webinar is presented by FirstService Residential Leaders in Property Management Solutions. We are North America's largest manager of residential communities serving the Chicagoland area. Our goal is to make being a board member a whole lot easier. Before we get started, a couple of quick notes about the webinar. If you are having difficulty hearing from your computer speakers, you can try calling in from your phone or using a headset or headphones connected to the webinar for better audio quality. You should also see the GoToWebinar control panel on your screen now. At any time during the webinar, if you would like to ask a question, you can type your question in under the questions panel. We will be answering some questions live at the end of the webinar, but please feel free as a question pops up to type that into the questions panel. Additionally, we're going to have a couple of polls throughout the webinar just to keep everybody engaged and potentially get some interesting insights. All right, so we will go ahead and get started. So today we'll be talking about meeting minutes. The minutes are arguably one of the most important documents of the association. Not only do they serve as the record book of the association, but there are legal requirements associated with keeping meeting minutes. So they're certainly not optional. They are very important official records of the association. However, it does not need to be a daunting task. We're going to go over the basic guidelines of meeting minutes and some best practices and tips to ensure that meeting minutes are recorded efficiently and accurately. We are going to kick it off with a poll. So there will be a poll showing on your screen shortly. The first question, kind of an icebreaker for today, is how long is the association legally required to maintain meeting minutes? 5 years, 7 years, 10 years, or forever? So we'll give everybody a chance to get their answers in. All right, I've got good turnout here. All right, so looks like most of the responses have come in. So the correct answer is 7 years. We actually got 53% of respondents got that answer right. So good job, you guys know your stuff. 7 years is the legal requirement to maintain meeting minutes for the association. All right, so now we'll dive into the basics of meeting minutes. What should be included? We're about to make some secretaries' lives very easy. So you should include the date, time, and location of the meeting, who was in attendance. This would capture board members, representatives from management, and any guest speakers. So if you have a vendor that's going to be coming, the association's attorney, those participants in the meeting should be captured. You do not need to capture, homeowners in attendance. They should not be captured as they're not actively participating in the meeting. You should also indicate that you have a confirmation of quorum, that you have enough board members present to actually call the meeting to order and conduct business. You should note the time that the meeting is called to order. And then the resolutions of the board. So the decisions and actions taken by the board at that meeting. And then finally, you should note the adjournment time. So as a follow-up to that, what should not be included? There are certain items that the board should avoid capturing in meeting minutes for a number of reasons, but primarily to protect the association from potential liability. Those items are discussion of items, directions to management committees or vendors, comments from board members or owners, whether or not they are directly related to the business being discussed. You want to avoid a detailed account of homeowner forum. And a summary or recount of advice received from the association's counsel, as it may result in waiver of privilege. So the meeting minutes are not to serve as the association's newsletter or a task list for the manager or committees or things like that. You really just want to capture just those resolutions by the board not any extraneous comment or really even discussion leading up to those specific resolutions. So it's pretty straightforward and not overly burdensome to capture just those resolutions. So diving a little bit further into some of the basics of meeting minutes, this question comes up quite a bit. Who should take the meeting minutes? So generally speaking, it is the Secretary of the Association. This is often defined through your governing documents, specifically your bylaws, where this duty is delegated to the Secretary. There are alternative options, though. Sometimes the Secretary can't make it to the meeting. Sometimes the Secretary is just not in a position to fulfill that task. So that can be delegated to any other board member. There's also the option to hire a third-party minute keeper. So there are services available for a relatively nominal fee to actually attend the meetings, record the minutes, and turn those over to the association following the meeting. You would want to avoid having a member of the management team capture those minutes just for integrity of messaging. These are the official records of the board, and members of management are not board members. So just to ensure that the integrity of messaging is maintained, ideally that should come from a board member or again, a third party impartial person capturing those minutes. Who should sign the meeting minutes? So typically speaking, the Secretary would sign the meeting minutes following approval by the board. However, sometimes people would like to have a second board member sign to attest to the accuracy of the minutes. So if the president or a second board member can certainly sign. If the Secretary is not available and we need to get the minutes signed to use them for resale or to post to a website, somebody other then the Secretary can certainly sign those minutes. How long should the association retain meeting minutes? So again, this is something that's dictated by the Illinois Condominium Property Act. Minutes should be retained for 7 years, and that is in hard copy format. So, we definitely encourage people to keep records digitally, post them to your resident portal, and just they're easier to distribute if you have them electronically. But hard copy, wet signature minutes should be retained for 7 years. All right, so now we're going to talk about some best practices relating to meeting minutes. The first item is to ensure that resolutions are properly captured. So resolutions should contain a clear description of what's being approved. So we have a sample resolution here that the Board of Directors of ABC Condominium Association resolves to approve the contract as presented by A+ Landscaping to maintain the exterior planter beds for a 3-year term at an initial monthly cost of X dollars per month. So it's very clear and specific what contractor is being engaged, for what scope of services, for what term, and at what cost. There's enough information here, so if there's any question about what was approved, be it a year from now, 5 years from now, you can go back to that resolution and have a clear understanding of what the board's intention was and what information they approved. You also want to make sure the director that made the motion is captured, as well as the director that seconded that motion. And then a result of the vote taken. So how many directors were in favor, how many were opposed, if there were any abstentions, and that the motion passed. Be sure to note any abstentions. So if there is a director that abstains from approval of a certain item, it is important to note that in certain circumstances. So a roll call vote is not typically required, meaning you do not need to list the names of the directors who voted in favor, the names of the directors who were opposed, and the names who abstained. However, there are certain situations where it's important to capture the name of the director that abstained. For instance, if, and really the most common is a director that is abstaining from approval of a previous meeting's minutes because they weren't there and therefore can't attest to the accuracy of them. So it's important to indicate that that director did not participate in that vote and abstained. Another common reason would be to a potential conflict of interest. So it is important to note that director abstained and to document the reason why, just so that there's clarity and transparency moving forward. Keep the format consistent. So ideally the same meeting minute template should be used to prepare each set of minutes. Not only does that make things much more efficient since you're not starting from scratch each month, having a consistent format is just helpful in making sure that record keeping is accurate and clear, concise, and easy to understand. One tip for board members: your managers will often include a proposed resolution for the board that the boards oftentimes adopt with a small tweak. In that case, feel free to use that verbiage. You don't need to reinvent the wheel. It can make your life much easier, especially if you structure the minutes to follow the agenda for the board meeting. It can really make preparation of those meeting minutes after the meeting really straightforward and easy to capture. Another best practice is to circulate draft meeting minutes quickly. So when we oftentimes we see that minutes are a last minute addition to board packets and people are kind of revisiting them a whole month later. It's really hard to recall specific details of things that happened well over a month ago. So our recommendation to ensure the most accuracy is to circulate those minutes shortly after a board meeting while the details of the meeting are fresh at everyone's mind. 2 to 3 business days or by the end of the week that meeting occurred is a good guideline to stick to. The next best practice is to sign minutes soon after approval. This is another one where we see sometimes a couple months of minutes are signed all at once whenever the secretary has a chance to stop by the office. If the minutes were approved as presented during the times that we are meeting in person, hopefully we'll return to that soon, a really good best practice is to just sign those meeting minutes right there at the meeting. That way you're good to go, there's no follow-up needed. Otherwise, ideally, those minutes should again be signed within a couple of business days after the meeting to make sure that they're available for owners for review, for resale document requests, and other business needs of the association. We are now at our second poll to make sure everybody's paying attention here. So the second poll that will be popping up on your screen shortly is: how quickly are the meeting minutes typically signed following approval in your association? So there's no right or wrong answer here, but just kind of an interesting poll to see what best practices are currently in place. All right, we've got some votes coming in here. All right, so it looks like most everybody has responded at this point. So we have 44% that are indicating that their minutes are signed within 3 business days. Fantastic. And it looks like the majority, at least half, have been signed within a couple of weeks after the board meeting. So that's great. That's a great best practice to make sure that those meeting minutes are available to your owners and for the business needs of the association. Fantastic. Now we're going to touch on some common pitfalls. The first pitfall is including too much detail. Again, the purpose of the board meeting minutes are not to serve as a transcript of the meeting. They shouldn't be used as your vehicle for communicating news and updates to residents. They're strictly just to capture the resolutions of the board. As such, we really want to avoid capturing things like discussion of business items, comments or observations, direction to management, a committee, or a vendor. The exception to this is specific delegation of authority. So if the board is specifically delegating to management or a committee certain authority to take a certain action, that absolutely should be captured in the minutes. But what we wouldn't want to do is state that the board directed the property manager to take a look at the garage door as somebody's reported that it's been sticking a little bit. That is not the time and place for that particular direction. A great vehicle for that can be a post-meeting checklist to capture those, tasks and directives that are issued during a board meeting, whether it's to the property manager, a committee, or a vendor, or even to board members for follow-up after the meeting. So I encourage boards to utilize that tool and keep it separate from the minutes. So you have a separate vehicle to ensure that there is some communication and accountability on items following a board meeting. The next pitfall is not including enough information in resolutions. So we've talked about not including too much extraneous information in the minutes. but where your resolutions are is where the detail is important and where it counts. So again, we have two proposed resolutions here. One of them just states that the association approved a landscape contract as presented. You know, while it's fresh in everyone's memory, that may be perfectly sufficient, but 2, 3, 4, 5 years from now, there's a property manager changes on the board, suddenly that resolution is not very helpful. The second option of a resolution is much more detailed. Again, it lets you know what's approved, what vendor is selected, what is the scope of services, and in this case, in this particular contract, the term of the contract, and the initial monthly cost. So the second resolution will be much more helpful in the long term should we need to go back and reference that decision in the future. Another pitfall is not approving and signing minutes in a timely manner. So minutes should be approved following the meeting and signed shortly thereafter. Most of you guys are already doing a great job with that. The purpose of this is we need to make sure those records are available to owners in a timely manner. They're also needed for everyday business of the association, including resale requests. Those documents are gathered as part of the annual audit process. Your CPA takes a look at those items. So very important that we don't have, 4 or 5 months of meeting minutes just kind of sitting out there waiting for signature. Failure to have these documents available in a timely manner can result in delays and frustrated owners. The next item, just to touch on, is a note on capturing homeowner forum. This can be a bit of a tricky one. Specific comments from owners, no matter how benign they may seem on the surface, should not be captured in minutes. So there's a couple ways that you can navigate capturing homeowner forum. The first option is to hold homeowner forum either before the meeting is called to order or after the meeting is adjourned, or in some cases, 2 homeowner forums are held. Because this is not part of the meeting technically, there's no business items being discussed, it negates the requirement to capture homeowner forum in the minutes at all. The alternative for boards that like to have it kind of midway through their meeting, maybe after the business, but before the committee reports, something like that, would be just to simply state that a homeowner forum was held. You do not need to dive into what topics were raised, how many people were in attendance, the names of homeowners that were in attendance at the meeting. You can just simply state that a homeowner forum was held. Okay, next we are going to touch on executive session. So this is a new-ish requirement. There was some recent case law that came down, specifically the Boucher versus 111 East Chestnut case, that has resulted in the requirement for executive or closed session meeting minutes. So up until 2018, associations did not capture executive session meeting minutes. It wasn't required, and most attorneys advised against it. That has changed. So if you are not currently capturing minutes for your executive session, you should start doing that immediately. Capturing minutes for executive session is very similar to capturing open session meeting minutes, but there are some slight differences. So you should certainly cite the date, time, and location of the meeting, who was in attendance, that you have a quorum of the board, and the time the meeting was called to order. Where things get a little bit different is the purpose of the meeting. So in this case, what we typically recommend is citing the specific section of statute in the Illinois Condominium Property Act that the board is permitted to discuss during executive session. So for instance, collection or discussion of delinquent assessments, or discussion of an owner's violation of the rules and regulations. We do not need to get super detailed or specific. We should not list out, specifically the unit that's delinquent or the action that's taken, or the items discussed rather. Just the kind of broad general topic is sufficient. And then of course you should note the adjournment time. And actually, just one other item I wanted to touch on for executive session. It is important to note that there are not decisions made during executive session, only discussion. So the board is not capturing any decisions in these executive session meeting minutes, just that the meeting took place and what topics were discussed. So the board would need to move back into an open session to actually take a vote on the items that were discussed in open session, and those resolutions would then be captured in the open meeting minutes. Just some clarity there. All right, the next topic to touch on are meeting minutes for committees and commissions. Should meeting minutes be captured for committee and commission meetings? So the answer is it depends. It's important to know the difference between the two of them to get a better understanding of when it would be required. So a committee, by definition, has decision-making authority within the scope of their charter and must have at least 2 board members participating on that committee. A commission does not have decision-making authority nor a requirement for the board members to serve on the commission. So in the case of a committee, since they are making binding decisions on behalf of the association, minutes should be captured. Those resolutions should be captured. In the case of a commission, since they are solely serving in an advisory capacity, minutes are not required. The exception of that would be if, in either instance, if a quorum of the board is participating. So just because you are not required to have 2 board members serve on a commission, if you have a 5-member board and 3 board members decide to serve on the commission, you now have a quorum. So in that case, that commission meeting would technically constitute a board meeting. So you would need to, of course, provide proper notice, but also capture minutes to capture what was discussed during that meeting. Recording board meetings, is it a good idea? So we often get this question come up quite a bit. Can the board record the meeting? The answer is yes. So section 18A9C specifically of the Illinois Condominium Property Act does provide that any unit owner may record a board meeting. And this does extend to the board. So the board can certainly record its own meetings if they choose to do so. In Illinois, we do not need to announce that the meeting's being recorded. You don't need to get consent or anything of that nature. But that begs the question, should the board record the meeting? So there are several reasons why a board may want to record the meeting, including to assist in preparation of the minutes to make sure nothing is missed. However, before taking that step, the board should definitely have a specific policy regarding use of their recordings and the retention thereof. When meetings are recorded, those recordings could become the official record of the association and may need to be maintained or made accessible just like meeting minutes. So as we talked about capturing too much detail before in meeting minutes, having a full recording of the meeting is kind of like providing the ultimate detail, which can certainly expose the board to some potential liability. So before taking the step to record board meetings, we encourage the board to consult with the association's legal counsel to make sure there's a thorough understanding of the benefits and the risks associated with the action of recording the board meetings. Okay, so that covers the presentation. We did receive a couple of questions in advance through the registration, so I'm going to go ahead and dive into those questions. But if there are any additional questions from those in attendance, please feel free at this time to enter those questions into the questions box, and we will get to those items as well. So the first question is, are the names of each director and how they voted supposed to be recorded? So this would be the roll call vote that we touched on a little bit earlier in the presentation. No, this is not generally required. However, it can be helpful in some circumstances, such as a board member abstaining from approval of previous meeting minutes because they were not present at that meeting. Can the actual amount of reserves be recorded? Yes. So it's not required, but it certainly can be captured. Typically, this is done under the treasurer's report. However, the board may wish to add a note just indicating that the amount is based off of unaudited interim financial statements. Again, they're not audited, that may change, so it's just a good kind of disclaimer to accompany those financial figures being given out. There we go, sorry about that. The next question was, can the board president make motions or second them? This is a really common question that we get. It's kind of a myth out there that a board president cannot make a motion or second a motion, that they can only vote to break a tie. That is not true. Any board member, including the president, can make a motion or second a motion at any time. The board president still gets one vote though. So if they make a motion or second the motion and there's a tie later on, they can't vote again then to break that tie. But yes, they absolutely can make a motion or second that. The last question is, can preparation of the minutes be delegated to another board member other than the secretary? Yes, absolutely. Preparation of the minutes can be delegated to any other board member. However, under the governing documents, the ultimate responsibility typically lies with the secretary. So in that case, if preparation of the minutes is delegated to another board member, the secretary should still make sure that they're reviewing them thoroughly to ensure that they're accurate. Okay, I think we've got a few more questions that have come through. Okay, we actually got a lot of questions, which is fantastic. So we probably won't be able to get to all of them here, but we will send some follow-up communication following the meeting, which will include an answer to all of these questions that we received here. Let's see. So the first question we have here is, who should review the draft minutes before approval? That is a great question. I would say everyone who attended the meeting. So that would be all of the board members, representatives for management. If you had a guest vendor there, they're probably not going to be interested in reviewing your meeting minutes, but certainly the board and members from management that attended the meeting should review those meeting minutes. Okay, we have another question. Do the minutes need to be signed? I've never seen that. Yes, we would recommend that the meeting minutes are signed, at least by the secretary. They can be signed by an additional board member to attest to their accuracy if desired. Okay, I'm just scrolling through here to see some of these we've covered in the presentation. See if we can get to one or two more questions. Here's a good question. Should executive session minutes be posted to Connect or the resident portal or made public or kept as private for only the board to see? This is one you would probably want to consult with the association's attorney. That being said, if they're being captured in a relatively vague manner, as far as just listing the section of statute that applies to what was discussed, you're probably completely fine to post them or distribute them. Sometimes when the association minutes are captured, they'll actually have the executive meeting minutes kind of like captured within the open session if they adjourn to executive and get back into open session. So if in doubt, consult your attorney, but if you're capturing those executive session meeting minutes appropriately, they should be fine to post. If they are requested by an owner, absolutely you would need to produce them. They could not be retained solely for private use. Okay, looks like we've got 1 minute left, so I'm going to see if I can get to one final question here. Okay, here's a good, just clarifying question. I am not sure what the difference is between executive meeting session and closed session. They're generally referred to interchangeably, so it's the same item. It's the portion of the meeting that is not open to unit owners. Okay, well, I think that is it on our time. So I appreciate everybody attending today. Thank you for the great questions and participation. We certainly hope that you find this information helpful. If you have fellow board members that could not join in today, or anybody that you think would find this presentation and information helpful, please feel free to share it. Anybody who registered for the webinar will receive a link to the recording as well as a PDF copy of the presentation. So if you had to step away or missed any part or just want to keep it handy, you will be receiving that information shortly. We will also include answers to some of these questions that we didn't get to. Finally, as a last housekeeping item, be sure to keep an eye out for the invitation to our next webinar. It is scheduled for March 4th. And the title will be Finance 101, Understanding the Standard Financial Package. So I'm sure there'll be a lot of great information in that webinar as well. All right, thanks everyone, have a great day.